Hi, my name is Scott Green, and I'm the managing partner for the Green Law Group in Simi Valley, California. And our firm is built for contractors and people in the construction industry. So today's webinar is all about mediation, arbitration, how to resolve disputes um, without necessarily going to litigation and the difference between mediation, arbitration, and litigation. This is August the 14th, 2020. So uh, I'll just say this generally that this webinar is general information, educational in nature, and for your specific matter, please be sure to talk to an experienced construction law lawyer. You don't want to take anything I say today as the absolute gospel only way to do it because the law changes on a regular basis with new cases and new statutes. And so what is true today may not be true tomorrow. And even if it is true, there might be an exception to the general rule, which would apply to your particular situation. So consider all of this good background info, but not a guide for your specific situation. So let me see how our screens are doing. Okay, so we have sponsors for these webinars, and there's no money involved. We don't pay them, they don't pay us. These folks are sponsors because um, I personally believe in them and their ability to support contractors. So that's why they're here. But one in particular I should point out is a company that I formed, that's Easy Law Construction Notices. And Easy Law does preliminary notices and mechanics liens and stop payment notices and bond claims. And they do them all over the country, but most of their customers are in Southern California. Um, and they're, obviously, I think they're a fantastic service. I started them in 1985, so they've been at it for a while. So I highly recommend you check them out. Then got Ventura County Credit Union in there, and you might think, gee, why is a credit union sponsoring a construction law firm? Well, they're my lenders, and they are heavily involved with the Ventura County Contractors Association, and I've just had really great, success with them. Um, Using a credit union, Ventura County Credit Union, is been wonderful. They tailor their service to the individual as opposed to walking into a big bank. The big banks may be fine, but you're a number. Ventura County Credit Union has, really come to, done great things for me, and I really appreciate them, particularly when, uh, you know, uh, business issues may be more challenging than they have been in the past. They could be wonderful. The Blue Book is, been around for, I don't know, 100 years or more. Um, and they are a fantastic networking opportunity for contractors. And Builders Bookstore in the San Fernando Valley in Southern California. Boy, if it's in writing and if it involves construction, they probably have it on their website. And they also have a store location, which is just fabulous. So check these folks out. Okay, so knowledge is power. So congrats to you to trying to learn a little bit more about your industry, the legal side of things. Here's this fair warning is all about, noticing that this is general info and not for your specific matter. Here's some information about my law firm. And then you get my pretty picture. And I'm not changing that picture. That's a few years old, but I have more hair in that picture, so I'm keeping that. There's my partner. I have a lot more hair than my partner, so I get to lord that over him. He's also a licensed general contractor, by the way, just and a bunch of other things, but fabulous lawyer. Uh, as are all of our lawyers. Jeff is our insurance guy, insurance coverage issues, which can be critically important, particularly if you're on the defense side of things. Mike Calipore, fantastic guy, has an advanced tax degree. He does a lot of our business things. He's also a fabulous litigator. He does estate planning for our clients. Um, and then Matt Bechtel, he's our head employment attorney and super sharp guy. You have an employment issue, which, by the way, don't take adverse action against your employees without talking to Matt or another experienced employment law attorney, because if you make the wrong call or you let somebody go, even if you've got a basis to do it, and they run and go see an attorney, and that attorney just audits, them to find out if you complied with all the various wage and hour laws, you could find yourself on the defense really quickly if you haven't done everything exactly right. You know what? Hardly anybody does everything exactly right. So check with us or another experienced law firm before you take adverse action against an employee. We encourage employers to use arbitration agreements so they can stay out of the courts. We also generally encourage severance agreements to limit your liability. And then there's also insurance options that you need to consider. So check in with us on your employment law issues. And Nate Cade is our newest associate, but he's a go-getter. He's on his way up the ladder in the legal profession, and we're just really delighted to work with Nate. So here, let's get into it. So litigation versus arbitration. So there are different things to think about right off the bat, and it really starts with your contract, because unless you have a provision in your contract that provides for arbitration and or mediation, you cannot force somebody to arbitrate. And I'll talk about what that arbitration is in just a minute, but it does start with your contract. So check out your contracts and see if you have any search them for the word arbitration. If it doesn't show up in your contract document, and that would be the contract you use or a contract you signed that somebody else drafted, if it doesn't require the arbitration of disputes, then the default is you're going to go to court. You're going to go into litigation when you have a dispute that you can't sort out. And so what does that mean if you go to litigation as opposed to arbitration? Well, if you go to litigation, you may have a jury trial. Now, in the construction industry, if you're a contractor, the sad truth is contractors don't have the greatest reputation with juries. Because everybody out there, either has had an experience that wasn't wonderful or knows somebody that's had an experience that wasn't wonderful. So if you did a great job, but you're on the defense and you're in front of a jury, you're going to be, maybe pushing a rock uphill here a little bit to convince the jury that you're a good person, and all those things that they're saying about you really aren't true, which is a bit of a wild card. So if I'm a contractor, and by the way, as a lawyer, I don't want to be in front of a jury either, because people have preconceived ideas about different professions. So if you're going in and you're a contractor or a lawyer, you're wearing a bit of a black hat. I mean, I remember a case years and years ago where I was asking a jury questions where I was defending a contractor in a construction defect case, and the contractor had built a set of condominiums. And one of the jurors in the question answer period, stood up and said, "Oh yeah, the same thing happened to my sister-in-law, and oh my God, what a nightmare!" and blah 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 blah. Well, that guy didn't serve on the jury, but everybody who was there to be impaneled got to hear him totally trash contractors. So, so that's one reason why you may not want to be in litigation. The other reason, and perhaps even more important, is, boy, is it expensive. If you go from start all the way through a jury trial and litigation in Southern California, that's going to hit your pocket pretty hard. I mean, I typically say that the average cost is going to be $250,000. Yeah, I know, you just fell off your chair. But it could be even more. Because in litigation, you have discovery, which means that, you get an opportunity to take depositions. So does the other side have an opportunity to take depositions. And if you're facing somebody who's got deep pockets, they can spend you into oblivion. They can take depositions of you and everybody who had anything at all to do with the project. And each deposition can go on for at least a day, sometimes more. And they're expensive, but it's a tool that is used in litigation. There are also other forms of discovery, written discovery, where you can be required to produce every scrap of paper that has any connection at all with the dispute. So just think about that for a second. Let's say you're on a project and it was a fairly good sized project. Let's say $1 million or more. Well, how much paperwork is involved with a project that size? You start thinking about the accounting alone, all of the invoices and releases and from the subcontractors and all of your work tracking expenses, etc. All of the plans, all the RFIs, all of the change orders, all of the text communications. We get in cases now where the amount of text is incredible. So all of that has to be turned over and organized. And we like to put things in chronological order so we can understand, when things happen. So that's expensive. So all of that happens or can happen in litigation, which means that, in my experience, most cases end up resolving in large part because the parties get, exhausted, frustrated, with the expense. And by the way, it takes a huge chunk of your time to pay attention to all of that. Now, it might be easy to say, oh, those damn lawyers. Well, it's the clients who really make the decisions about, how hard they want to go in litigation, and the decisions are always ponied up to the clients by the lawyers. So you can't just blame the lawyers on how these things get out of control. Sometimes, we'll be working on a case and we'll be strongly recommending that people settle out or consider, some other means of resolving the dispute. But, we're not the deciders. We're just the recommenders. So anyway, litigation, super expensive. Also, it takes longer to litigate a dispute than it would to arbitrate a dispute. And that's because the courts are busy, and also the courts, their calendars are not reliable. So you might be all set to go in and start your trial on a Monday, let's say, and your lawyer packs up all of the documents, you get yourself down there, the witnesses are all ready to go. You go on down to the courthouse and you find out, oops, you got bumped. No room at the inn. Something came up. You know, maybe the judge had to take an older case ahead of you, or a criminal matter took priority. Any number of things can happen. And now you're packing up and going home. Well, guess what? That just cost you a lot of money. You know, your lawyer had to prep and get everybody organized, and you run down to the courthouse. And now you got to start over some days, weeks, or maybe even months later. And boy, is that frustrating, and boy, is it expensive. The other thing about litigation is you might go through the process and win, but in litigation, the judgment can be appealed. Now, that can be good or bad. If you're the winner, you don't want it to be appealed. If you lose, maybe you do. But that's, the only guarantee there is it's another potential layer of expense and time. If you go through the appellate process, that might be a year or more to figure out, okay, what ultimately happens. And guess what? That's expensive as well. So those are the highlights for litigation, starting with your contract. So let's see what we got on the next screen here. Oh, it's kind of stuck. Let me get some help with that. Okay. So this is just a little bit more about what I was talking about, the time track, etc. So let's focus now on arbitration. What is arbitration and why is it different than litigation? Well, arbitration's binding. What does that mean? It means that whatever result you get. There's no appeal. Now, I'm talking generally because you could have an arbitration provision in your contract that does allow for an appeal. That's unusual. Arbitration doesn't involve discovery generally, but you could have a specific arbitration provision in your contract that does provide for discovery. So you have to pay attention to your contract and what it says, but generally speaking, no discovery, which means no depositions, which means that a much financially stronger party can't use the discovery system to try to leverage a resolution. The other thing that is good to know about arbitration is generally faster. In California, as the screen indicates, 9 to 24 months to get to trial, arbitration 3 to 6 months. Now, that doesn't mean you couldn't have an arbitration that doesn't take 9 months or even a year in a really complicated matter with multiple parties. Also, you might get to trial in 6 months if you have a relatively simple thing. Or maybe you even have a situation where you file a lawsuit, the other side doesn't respond at all, so they default, and you get the whole thing done in 3 months, 4 months. So again, general rules could be exceptions, but in my experience for contractors, time is very critically important because most of the disputes involving contractors involve situations where you did the work as a contractor, but you didn't get paid. So if you're already out a big chunk of money, and your lawyer says, well, it could be a year or more, that's going to hurt. And in that year or more, you're going to be getting a bill every month to pay for the litigation. That's going to hurt. So if you can get that dispute resolved sooner, well, that means it's going to cost you less. Now, arbitration is not inexpensive. Sadly, there's no, reliable reliable, inexpensive way to resolve these disputes in construction, which can get quite complicated. But in arbitration, instead of a judge, you're going to have an arbitrator. And that could be a retired judge, or it could be a senior construction attorney with lots of experience. And both sides are going to have an opportunity to weigh in on who that might be. Usually, arbitrators are selected from what we call a strike list, or maybe each side gets a list of half a dozen potential arbitrators, and both sides can strike two or three of them. And then who's ever left, ends up being the selection. But arbitrators charge by the hour, and they charge, a lot. So you can have an arbitrator who's charging, $400, $500, $600 an hour, and they're going to be charging you for reviewing all the documents, conducting hearings, writing up the decision, etc., being the referee or managing all of the hearings. We have a case now in arbitration that has been going on for, 6 months or so in the arbitration phase with lots of hearings. It's a very complicated case. And I'm going to blow the lid off this and tell you that in that particular case, the attorney's fees just done for our client well over $1 million. Now, the outcome in that case is going to swing, $5 or $6 million to one side or the other. So that million, is, maybe warranted based upon the outcome. And our guy really didn't have a choice. He got sued for big bucks, and he was owed big bucks. But that's a tough situation. But that's an example of how it could go. Most of our cases, are probably less than 200,000. But we always have to try to figure out the business factors involved in these disputes based upon upside, downside, potential cost of litigation or arbitration, and figuring out, what is the best business and legal approach to take. It's not always an easy calculation because, there are no guarantees about, getting a particular outcome based upon the decisions you make. There's always going to be a risk. So it's complicated, with the only guarantee being you're going to get a bill every month until the matter's resolved. Which leads me to mediation and a conversation about what that is and why you might want to consider that. Now, mediation is also generally provided for in your contract, where in the dispute provisions of the contract, it may require that, as a first step toward resolving a dispute, the parties agree to go to mediation. Now, what's mediation as opposed to arbitration litigation? Mediation is non-binding. Well, what does that mean? It means you sit in an informal conference room, perhaps, and you pitch your side to a mediator. The mediator then goes to usually a different room to listen to the other side's pitch. The mediator is going to come back to you and say, well, I understand your position, but, you've got some weaknesses. And the mediator's job is to basically beat up on both sides to convince them that, their case may not be as strong or as bulletproof as they think it is. And also to point out that if the matter doesn't resolve in mediation and it continues forward into arbitration or litigation, that the only guarantee is going to be you're going to spend a lot more money. So perhaps it'll be smart to, take less than you think you're entitled to now in mediation, resolve this dispute, put it to bed, and get back to the business of running your company as opposed to being engaged in a long-running arbitration or litigation. So that's mediation. You know, it's an alternative to avoiding, you know, arbitration litigation. But it also means that, you know, when both sides say, yeah, let's go mediate, what is kind of baked into that decision is you're saying, I'm going to compromise. I'm going to take less than I'm owed. Uh, and as a for instance, you're not going to get your attorney's fees back in mediation. So let's say, you know, the cost of mediation, you could have a multiple day mediation, or you could have a mediation that just takes a few hours, but you're going to pay the arbitrator, I'm sorry, the mediator, and then you're generally going to have an attorney work the case up for you. So the attorney is going to, you know, create a presentation, what's a mediation brief, maybe a visual, you know, presentation for the mediator. Uh, the attorney has still got to understand the case and what the different issues are and the law is. So you're going to spend money there, but in mediation, you're not likely to get it back because in mediation, it's not one side wins, one side loses. It's both sides compromise and move toward the middle. And when you're compromising and moving toward the middle, you're going to give something up. You're not getting your attorney's fees back, and you're not going to pay the other side's fees. And then let's say you were gunning for $100,000, you're not getting your 100,000 because if you go into mediation, you say, "Look, I want my 100, or I'm walking." Well, you know that's going to be a really short mediation because you're not going to get agreement on that because the other sides are going to say, "Well, if you think you're entitled to everything." And you're not willing to, you know, budge, then what the heck? Let's just go to arbitration or let's just go to trial. So if you're going to consider mediation, you're going to have to be flexible. In my experience, mediation resolves, you know, a significant number of cases. You know, I've read in years past that 80% of disputes will resolve in mediation. And I would say that's, you know, that's probably pretty matches up pretty well with my experience. Um, although, you know, as soon as I say that, I did a mediation a few weeks ago, and we thought that it was an appropriate matter to resolve in mediation, but the other side wouldn't move. They, instead of coming closer to where we were, they got aggressive and they got farther away. So unfortunately, that particular matter didn't resolve, and that's going to move on to arbitration, where there will be a binding result. So, oh, I went the wrong way. Okay. Here's something important to know about arbitration. Remember, I said in arbitration, you don't get discovery. So sometimes lawyers call that trial by ambush because the benefit of discovery in litigation is by the time you get to trial, you know everything the other side's going to present as evidence. You might know everything their witnesses are going to say. So you have a much better idea of, you know, the strategy you should use in a trial because you drill down on everything that's going to happen. The other side is going to present as evidence and their witnesses and their documents, and they've done the same to you. So there are no surprises in litigation, or at least fewer, particularly if there's been a lot of discovery. Although I will tell you, I've never had a trial where I didn't continue to learn things about my case right on through the trial. Because even if you've had the opportunity to take a deposition of a witness, It may not be exactly the same thing coming across at trial. So when you're in arbitration, there's a risk that, things will come up that you had no idea about, or your lawyer had no idea about, because they didn't get an opportunity to take depositions and look at all of the documents. So that is a risk assessment you have to make. And then this question here, can you be forced to give up your right to a jury trial? No, you can't. You have to voluntarily agree. But an awful lot of construction contracts will have standard arbitration language in them. And so unless you strike that out, you're going to be stuck with arbitration. But remember, from my point of view, I think that beats litigation. I would rather be in arbitration. Okay, here's just some examples of form contracts that have arbitration provisions in the templates. And here we talked about this a little bit already, where all of the arbitration provisions are not the same. So you need to read them carefully, and which is true about your entire contract. Contracts are about shifting the risks between the contracting parties. So if you just, get a big contract and all you're looking for is where do you sign and is the amount of money correct, boy, you're blowing it. You need to read that thing carefully, because let's say there are liquidated damage provisions in the contract that you have no idea about because you just kind of rush through it. And then at the end of the day, all of a sudden you're looking at $5,000 a day liquidated damages because you didn't get the thing done according to the schedule. You don't want to find that out after you're already neck deep in the contract or in the project. So you must read your contracts up front. If you don't, you're taking a huge risk. So, and here you go. Here's me saying, read before you sign. If you have questions about the contract, get those questions answered before you sign, and that can include consulting with an attorney. Here's more about some of what we've talked, and kind of a word to the wise that faster is not always better. So even though arbitration is faster, sometimes you really do need discovery, and so litigation is a better option. If you have no idea what the other side's complaints are, and you're stuck with arbitration, you get no chance to take depositions, it can be dicey. Okay, folks, that's it. We powered through another webinar. We try to keep them short and a little bit punchy. And I know there are you probably have questions. So you can shoot me an email. I'd prefer an email over a phone call. But if you're absolutely determined, you can give me a call. I'll try to get back to you as soon as I can. But email is just a lot more convenient to schedule, and you don't get phone tag. So listen, I hope this was informative. And if you have questions, let me know. And go out there and conquer the world. And I hope that COVID's not a concern. Well, heck, it is a concern. I hope you're navigating through this COVID world successfully. Good luck to everybody, and thanks for listening.